Hey, IP friends! Welcome to episode 82. Yeah, super excited because we have 80 more episodes until we reach the 100th episode, and I'm so excited. But yeah, if you haven't listened to the previous episode, which is episode 81, where I talked about the Afrochella Coachella case, please listen to it. Like, wisdom was shared on that episode. There's even a Twitter version. If you want like a summarized version, there's also the Reels version or the short video format version on TikTok and on Instagram. Now, for my returning listeners, thank you guys for always coming back to listen to me talk about intellectual property. Don't forget to like, share, review, rate, and retweet. Now, today's case, you guys are gonna love it, boy. Welcome. And let's delve into our conversation for today. So today's IP series episode, I will be analyzing 3 different cases, and all of these cases just kind of hit me because when I came across the first case, I was like, how am I going to tackle this? I've already talked about trademark opposition. Then the second case came along, and I was like, this is actually leading somewhere. And that second episode was sent to me by a colleague. We used to work together at Infusion Lawyers. His name is Marlon Moses. He is a cyber security and tech policy practitioner. So you guys can check him out and also his content as well. So he sent me that story. I think that's like the third story he has actually sent to me to talk about. The first one was the Ugomoye case. He tagged me on the post and I did an extensive post about that. I did a podcast and I think I also did a Twitter version of that conversation. Then the next one, which I'm still working on it because I feel like I haven't really gotten like the vibe on how to go about it. But I'm not going to mention it. So this is like the third story he is sending to me. So guys, don't forget, if you have cases you want me to review or share my thoughts about it, just email it to me at ipseriesinfo@gmail.com or send me a DM at ipseries1 or my personal page at Esmeralda99. Or if you have my phone number, just WhatsApp it to me. You get it? Yeah. And then the third one, I was scrolling through LinkedIn and it just popped on my timeline. Like, I've gotten my 3 stories. Normally I would have done like part 1, part 2, part 3, but I'm just gonna merge because they are all centered about trademark, but different versions of trademark, from application to trademark opposition to the 3 cases actually features trademark opposition anyway. So the first one is the Laila Ali, who's the daughter of the late American professional that's the late Muhammed Ali. He was a professional boxer. She had filed an application to actually register her name, and it was opposed by a licensing company that had bought the trademark right to Muhammad Ali's name, his image and likeness. So it was like, oh, this is getting exciting. So things that okay, let me just go through all the questions, or the cases rather. Then you have the DUNCIC case with his mother over his name, and then you have one about the Eng's family, ENG. So it's like a Chinese name. So it's written the English version and then the Chinese version, and I was like, yo, I gotta talk about IP and family. What is the interplay? What's the relationship? How do you deal with all of these things when it involves your family? So I hope you guys find this really interesting, because I was initially going to do a Twitter mini blog series, but I seriously thought about it and I was like, let me just do a podcast version for once, like without having to actually create different media formats. But if you guys also want a Twitter version, please send me a message. You can also send me a voice note on Anchor and I will listen to it. Trust me, I enjoy listening to my IP friends. So yeah, let's start with case number one. So before I go start this one, let me just tell you what, like, when I came across those cases, what I was thinking about. So, like, grounds for opposition of a trademark registration, when it's descriptive, when it's geographically descriptive, when it suggests a link or connection to a person or a brand. Is there like use in commerce? Is it distinctive enough? You know that one of the basic requirements when talking about trademark is that the mark has to be distinctive in nature. Now, has the mark acquired distinctiveness? Is the applicant's mark similar in commerce or connected to the goods and services? Is there proof of likelihood of confusion? And if the registration is successful, will it not amount to an infringement, either directly or indirectly? Is the registration misleading? Is the registered mark famous? Are there existing domain names? Will the registration amount to bad faith? So those are the things that were, just going through my mind. I was like, ooh, this looks nice, this is exciting. Yeah, so another trademark case today. First off, I already told you guys that Laila Ali, the daughter of the late American professional boxer Muhammed Ali, had filed a trademark application to trademark the name. That's to trademark her own name, but it was opposed by Authentic Brand Groups, who has the majority stake in the late professional boxer's trademark name and likeness. Now, sometime in 2006, late Muhammad Ali, he was going through some life crisis. He was sick, he was battling Parkinson's disease, and said that, the only way I can raise funds was to sell my trademark to my name and also likeness to a licensing company. So you can imagine that in 2006, he sold that for about $50 million. And we know that for athletes or celebrities, your name, your image, your likeness can be monetized. You could get into branding, branding jobs, sponsorship, endorsement. You can also create merchandise for yourself. You can also license the use of your name, image, and likeness to a third party. But in this instance, he did not license it. He actually sold it out. And once you are in the public eye, for instance, like I said, you can monetize your voice, your signature, your name, your image, your likeness, which in intellectual property is regarded or called personality rights, or right of publicity, or image right that can be used for endorsement or licensing, just for commercialization or exploitation. We in Nigeria are still developing in those areas. At least I do recall when Omotila trademark her name, God, the internet was not having any of it. You're like, why would she do that? Is she preventing other people from handling and what's that? And I was like, but it's not like that though. I mean, so we're seeing more celebrities, taking the initiative to trademark their personal names. You can actually trademark your personal name, guys. So first you're using it for commercial purposes, you're using it in commerce, and you're consistently doing that. You don't just register let's say Henry in say class 9 and then go and rest. Nah, you have to monetize it, which is where the use in commerce comes into place. Now the reason the licensing company opposed her registration was, one, they had stated that consumers may link her name or her supposed trademark to Muhammad Ali, which they now own. They also talked about dilution by tarnishment, whereby her registration will cause harm to their brand and also affect the reputation of Authentic Brand Groups and their right to delete Muhammad Ali's name. Then they also talked about likelihood of confusion, which is like one of the fundamentals of a trademark application, and you must show that the person intending to register that mark is, as in, consumers are going to confuse their mark for your own mark at the end of the day. So it just got me thinking, so does that mean someone from So my father, let me just use my father. I bear Chinda. Chinda is spelled Chindah. Does that mean someone, say my sisters, cannot go and trademark their name together with our surname? Because I had monetized it and, ended up selling my name out. I mean, you also, I think like the very first case that came to mind was the Fenty entertainment case and the Fenty beauty case between Rihanna and her father. And you see that a lot happening when family members want to exploit or commercialize the family name. And then you start asking, is the person doing this because he wants to take advantage of the reputation you've garnered over the use of the name and all of that? So those questions comes in like, okay, why did this person not think of any other name other than the name that I already used for my own trademark? So that's it. I'm just putting that case one side. So you see that when you want to do a trademark registration, which is why I always tell my clients or people that reach out to me to consult to do trademark registration, like, you're just applying. You're still in the process of applying. No one has given you a certificate stating you now have the exclusive right or own the exclusive right to that mark in the class that you registered. So your acknowledgement or your acceptance is not proof of ownership. Sorry, yo. I mean, I know that when you're doing your NAFDAC registration, they always like bring an acknowledgement or acceptance letter, and people are like, oh, I have a certificate. You don't have a certificate yet. Your application is still pending. It's not been formally approved. But that's about that. So they were opposing it based on Section 2, Paragraph D of the Lanham Act, which is like the US Trademark Act. So yeah, so let's look at the second case. So this is the first case. Now you see that the application was, opposed from, the very get-go, not waiting for them to register and then go and oppose and then start spending lots of money. So the second case is a rather interesting one, which is a case between a mother and a son. Now, turns out this basketballer, when he was still a teenager or underage, his mother went ahead to trademark his name, which is Luka99 in class 9, which is for non-medical soaps, then class 9 for computer software, class 25 for clothing, class 28 for games and playthings, class 35 for business management of promotional goods for sports, personalities, retail stores, etc. And then class 41, which was, let me see, that's about 6 classes. Lots of money for the trademark attorney. Now, the basketballer, who is now 23 years old, is now opposing he's challenging his mom's registration of his name. So sometime in November of 2018, his mother, Mirjam Poterbin, had applied to register his name, Luka99, in the classes I mentioned earlier, and finally got approved 7th January 2020. So you see that trademark registration is not like a 2 month, 3 month thing. It's a long process because the examiners have to verify that the mark in question you want to register is distinctive in nature, and also is not similar to any existing mark out there. So now he has applied to the US Patent and Trademark Office to cancel the mother's registration because, one, she registered it and abandoned it, and that's not a ground for applying that someone's mark should be cancelled. So if you're doing a trademark registration, make sure you use it in commerce. You don't just register and then abandon it, because you also need to pay renewal fees. So make sure that whoever you're consulting tells you all of this. So you get free information regarding this on my podcast, but when we leave the podcast and come to the DM, yeah, I need to talk money. Then he also said that the name consisted or comprised of a name or portrait or signature of someone who is still alive, and that there was no consent gotten from that person or the surviving spouse, and that the registration was a false suggestion of a connection with him, whether with, okay, let me put it away. So it's a false suggestion of a connection with persons living or dead, institution, beliefs, or national symbol. So I already stated the classes that the mother had registered. So he was doing registration in class 9, 16, 18, 20, 21, 25, 28, 30, 32, 41, and 42. Now in class 28, said it was a word mark for the original hoops of Luka99, and it was applied for sometime in June last year. Then class 36 for both a word and device mark. So there are ways you can register your mark, either you do a word mark or a word and device mark combined together. So a consultation will give you more insight on how you should register. Sometimes it's advisable that you do one or you do both. You do both of them so that someone doesn't take advantage of the fact that you did not explore the other one. Again, free information. I did try, Abby. Yes, I did try. So in the US, grounds for refusal in the US is that the mark in question is descriptive or deceptive. It is commercially phonetic. There's a likelihood of confusion, the sound appearance or meaning when defined or transcribed. For being geographically descriptive, if it doesn't function as a trademark by meeting the distinctive test in the applicant's good, but it's just a decorative feature, or that the best way you can avoid this is to conduct a search or get clearance, or opt for a coexisting trademark agreement. I think this is like the second or third I'm talking about a coexisting trademark arrangement. Yeah, I talked about it in the Coachella case because of how similar the names were. So you can, if you need more insight as to that, you can check out the USPTO, that's the US Patent and Trademark Office website for more information on grounds for refusal in the United States. In Nigeria, it is almost similar, yeah. But then you have to show that the mark question is not distinctive enough, that there's likelihood of confusion, that when it contains the following words such as patent, patented, design, copyright, use of the coat of arms or national flag. I talked about that when I did the Nigerian Independence Day short video as well, what can be trademark, and where you're not allowed to use the coat of arm or the national flag in your trademark. So we have similar provisions, but then it's best that you find out what is obtainable in the jurisdiction that you are opposing the trademark, because trademark as an intellectual property mechanism is territorial in nature, and it is only the jurisdiction where you have power that you can have a say in terms of opposing someone's registration. So today's case, the third case for our discussion when I was talking about the family and IP case, is an Asian case, specifically from Singapore. So sometime, I think I came across that publication last week. So it turns out that sometime in June this year, the Intellectual Property Office of Singapore gave its ruling regarding a famous trademark to Eng's Noodle Shop, which was then decided in favor of the late founder's heirs, who happens to be late Eng Ba Eng. So it's Ngbaeng. Now it turns out that the intellectual property office adjudicator. So sometimes in an intellectual property dispute, you have different mechanisms for resolving. So either you're going to court to litigate, or you're exploring out of court settlements such as adjudication, conciliation, mediation, negotiation, arbitration. And in this instance, they had an adjudicator sit over their matter. So it just kind of shows that each country has the way they resolve their dispute. In Nigeria, we have a tribunal, the trademark tribunal, who will sit, and the registrar will be part of that hearing. or you go to the Federal High Courts, or you go to the multi-door court as where a mediator is appointed. It all depends on how the dispute resolution, that's if it's in a commercial transaction, how the dispute resolution mechanism was couched, and if it's not in an opposition setting such as this, it's the registry that will handle that. So now a brief background about is that the late Eng started his business in sometime in 1962. After he took over from his father in 1962, and in the 1980s he opened a store bearing the name Eng Shashu Wantame. Apologies to any Chinese that listen or Asian that listens to this. And stayed in business from the 1980s up until 2009, when his son decided that he was going to assist his father. So it kind of gives like the Igbo vibe where they're like, oh, you know, apprenticeship and the rest of them. So Desmond, who happens to be the name of the son, decided that okay, he was going to assist the late Eng in the store. So he did that from 2009 to 2012, you know, trying to get to familiarize himself with the family business. And then they were approached by a businessman called Jason Sim, who was like, okay, let's go into a partnership where we expand the noodle shop to other territories. And then, you know, it seemed like a good idea to them, and they decided to go into that business with them, and, you know, incorporated the business in sometime in February 2012. And then the next year, late Eng died. And then 5 years later, in 2018, parties decided that they were going to terminate, or the relationship between Desmond and Jason Sim just, you know, fell out, and they ceased operation in that 2018. Now, remember that Desmond took over from his father, and the company name became Eng Noodles House Pte Limited. So that business ceased operations, and the two companies turned out that they decided to go into competition with each other. Now, Jason Sim's wife formed the Eng One-Time Noodles. I mean, you came into business with me and decided to use part of my business name for your business name. Isn't that going to cause likelihood of confusion? So they opened their own noodles, Eng's One-Time Noodles shop on that same day that they terminated their relationship in February 2018, while Desmond and his other two siblings formed Eng Sha Shu One-Time Me Pte Limited few days later, which is like March 5th, 2018. That's my father's birthday. And they opened the Eng Sha Shu One-Time Me shop. And then from that time, from June to July, they decided they're going to file three different trademark of the name Eng's. But Jason Sim's wife opposed the application on behalf of her Eng One-Time Noodles Pte Limited, claiming that there was passing off and there was bad faith. And you know, when you're talking about a mark being registered in bad faith, you have to look at three elements, which is goodwill being misrepresented and the damage caused to the brand, which is also kind of like similar to passing off as well. Now, on the grounds of passing off, the Intellectual Property Office of the Intellectual Property Office of Singapore held that Desmond's company, that's the previous company now between Desmond and Jason Sim, stopped existing since that time, and therefore they had no goodwill in the name Eng, in the Eng's mark. That's the first blow that they got. Then she further went ahead to allege that Desmond's mark was identical to hers. I mean, how would you be claiming that you went into business with Engs, Lady Let Engs and his son, and now you're saying that their name is identical to yours? Meanwhile, you went ahead to register, open a name called Eng Shasu Wantami, which is similar to Desmond's their name. So she also said that the Engs marks in their registration, they also had materials that had their name. But again, the intellectual property office of Singapore adjudicator refused and said that they had not established that the Engs mark was associated or exclusively with them, because the use of Engs marks was for like a total of 6 years, from 2012 to 2018, which was like a fraction of what the late Eng use was. You remember that the Desmond's father started using the name Eng Sha Sinwantami in the 1980s. So, and then you are coming up saying because they're using it from 2009 to 2012, you have the rights to that name. And you know, following the relationship, you said that, oh, we are the main owners of that. So on the grounds of bad faith as well, the adjudicator also noted that the knowledge that they as a third party had, a third party using identical or similar mark in relation to or identical to or similar goods or services does not amount to and does not constitute bad faith. Now, under intellectual property, the concept of bad faith or trademark squatting is that where an applicant files for a trademark with the intention of hijacking or taking it from another person, then that's your act basically is done in bad faith. You don't have good intention, especially in the jurisdiction where the first to apply principle works. So for instance, in Nigeria, we apply the first to file principle, and if someone decides to go and register IP series before me because he wants to hijack it from me, that is you registering a name or word or mark in bad faith. Now, in addition to that, they said the adjudicator held that while there is a duty to investigate the bona fide of a mark before seeking registration, the circumstances could lead to a reasonable person to harbor suspicion as to the propriety of the proposed mark. And then, because Jason Sims did not produce any direct evidence showing that that Desmond knew that he did not have the right to register the Engs mark, therefore they do not have that right as well, and they ended up losing the rights to the famous Engs noodle shop name. So and again, you know, it's fascinating because the function of a trademark basically is that when enforced, it protects the owner from any act of unfair competition. And this is what Desmond probably had going for him, because I would say Engs was like an unregistered mark for a very long time. You can see that it was only up until 2012 that they eventually registered the Engs business name, incorporated it, and became like a legal entity before any other thing. So that's about it for the 3 cases. I'm just going to highlight the interplay of family and IP and what, you know, intellectual property owners who are family members should do going forward rather. So just to wrap up this conversation, I mean, if you really want to know more about what it takes to oppose a mark, please check out the previous episode where I talk about trademark opposition, when you can apply to cancel a mark, when you can invalidate a mark and strike out a mark, and the rest of them. But for this case, one thing we need to know is that families who are in business should have like a succession guideline for how an intellectual property, for how an IP, which is like an intangible asset, can be used by a family member. I wouldn't want to say so much based on our last case study, which is the Engs mark case, but having or retaining the services or working with an intellectual property lawyer will go a long way for family business, um, family businesses. Then the legitimacy of trademarking personal name. We saw how Nigeria reacted to Omotla trademarking her name. We're also seeing how the case between DUNCIC and his mom is going, and there are conversations that the mom should just do assign or transfer DUNCIC name in form of a trademark back to him in all the classes that she registered, so it's not abandoned and then he's able to monetize. I mean, now he's 23, he's no longer a child, and he wants to be able to monetize that which he has. Also, in the case of, a child owning an intellectual property, if it's registered by an adult, please let it be held in trust and later transferred to that child when he becomes an adult, which I think that's what should happen in Luke's case against his mom. I mean, somehow when people hear, oh, you see your mother, she carried you for 9 months, she did this. Yeah, she did all of that, but IP is business. Like, how does one be playing with my name like that? Like, even when let's assume they had this conversation, like, look, mom, I really want to, be able to use my name for commercial purpose. And she's like, nah, I own the right to your name. Yeah, you gave birth to me, thank you. You gave me a lovely name, thank you. But because of I became able, I mean, Luke's case is very interesting because he started playing basketball, I think as early as 12, 13, and that's like a span of 10 years. You'll be able to position yourself to the point where you can now commercialize and, explore your personal name, so a third party doesn't do it. So I can imagine how the fight is going to be if it was a third party, but this is blood, flesh and blood. How are you going to react to that? How's the conversation going to be? Is it going to be like a very tense conversation? You know how parents can be, I don't want to say dramatic, but yeah, they can be dramatic when they want to be. Next up is that in the event of an IP related dispute, especially when you're doing like a trademark application, there are stages and procedures to resolve disputes about a registered or an unregistered mark, which, as you can see from our case, began with opposition. So all of these 3 cases began with opposition. And opposition, so in Nigeria, you have a timeline of 2 months to oppose an application. Failure to do that means it's going to move on to certification. And that is where you're given the chance, if you eventually decide to, if someone decides that they're going to oppose your mark, you're given the opportunity to come and explain yourself as to why you feel your mark is distinctive enough. Oh my gosh. Ugh. Okay, why you think your mark is distinctive enough and not similar to the mark that is already been registered already. Then there are also grounds that you need to also prove: non-use, abandonment, all of those things. Again, your trademark attorney, your trademark lawyer, or the trademark firm you hired will do all of that education for you. For Laila's case, I think it's a bit, I don't know, I just kind of liken it to Rihanna and her father's dispute. But in Laila's case now, her father is not alive. He had already sold the rights to his name. You get his name, image, and likeness. So I just feel parties should just come up with like a coexistence trademark agreement, state the terms and conditions that Laila Ali has to stick to in terms of use of the name Ali. I think because of the name Ali, that they are pushing against it. But let's see how that goes as well. Then owners of intellectual property, such as trademark, image, names, likeness, can choose to commercialize or exploit what they own by selling it. I really don't like telling people to sell their IP because I feel I just mentality that, okay, you sell now and then the price goes up and you're like, oh, I just lost that, but that's just me. We like money, so we're thinking plenty things. But that's a way for you to, generate revenue for yourself. Just like in Muhammed Ali's case, he opted to sell to a licensing company for $50 million as at 2006. So, the money being big. You can also opt for partnership, business transactions or creating a franchise, going to a franchise arrangement like the Engs family did. But then it ended up not working out well, and they had to, terminate the business relationship and close down the stores they had expanded to, and just, everyone said like, okay, I'm going to use Eng. So I feel the other party, Jason Sim's wife, who was opposing, was even the one that was trying to use the trademark in bad faith, because trying to hijack it from the late NG Bar's Eng's family. I mean, that business had been in existence since the 1960s. This is like the third generation right now, owning Asa then the unregistered Eng's mark. And you also went ahead to name your brand Eng's Noodles. So then you look at the scenario between Mirjam, Poterbin, who what she did with DUNCIC's name in terms of registering in various classes, trying to monetize and create merchandise for her son, explore and exploit the image rights and right of personality that he has. Then IP valuation and long-term goals gives a family insight as to the family's intellectual property portfolio, the strategy they can use, long-term goals they can have, and how to position themselves. There's an option to create a franchise by expanding into other territory. What are the terms and conditions? What part of the business can you license? There's also another case. That's like a restaurant's case. I was going to talk about it, but I think I'm still going to talk about it because it's like a 10-year case and there are lots of documents to read, but I'm going to definitely do it before December, while I'm preparing for my December Christmas edition series. This is like the fourth. Yeah, this is the 4th year running. Then in a family-owned business, have a succession plan in place. Be ready to evolve, document all your transactions, creativity and innovation. Don't abandon your registration and then let a third party come and want to monetize and take advantage of your goodwill and reputation you've garnered over years. Always opt for a multi-layered IP protection. So other than trademark, you can do design right protection. If you have products or merch or logos, you can opt for copyright registration. You can opt for trade secret. I mean, the Engs family had the opportunity of protecting their trade secret or confidential information as to how the Engs noodle shop became what it was from the 1960s and staying up until the 1980s, and also still being in existence till today. What is that confidential information? What is that secret that keeps Engs noodles shop alive till today as a business person? That is just me thinking out of the box. Every other thing will just be, assignments and licensing models, franchising models, research and development, all of those things. Do not adapt a DIY approach with your intangible asset. That is a no. Do not do that. Don't wing it. Do not wing it. Do not say, I'm trying to save funds, I don't want to pay this person. And then also clearly define IP ownership very well. I think maybe what Muhammed Ali would have done to protect his family was to say, okay, why I transfer or I sell the right to my personal name, my children or successors or heirs can be able to also trademark their names and the rest of them. But that did not happen. That's just me thinking outside the box right now. So yeah, I hope you found this episode about family and IP interesting. Let me know what you guys think. Yeah. So we have done with this episode. If you learned something, please let me know. Send me an email to ipseriesInfo@gmail.com. Don't forget, your intellectual property is your intangible asset that has commercial value. Do not jeopardize it. Don't do anything that's going to make you regret in future. Have long-term goals, involve your estate and heirs. Have the right policies. I think I'm ranting right now, but yeah, I had a swell time recording this. I hope you also find this episode insightful. If you did, show me love, baby. Show me love, IP friends. Sorry. Show me love, IP friends. I really do appreciate you guys always coming back to listen to me. And yeah, see you in the next episode. Bye.